All right. Take it away, Lindsay.
All right. So, like Christy said, I'm Lindsay. Good to see you all on here. I'm going to try to go over this relatively quickly, just so that on the back end, we can talk about questions or go over hypotheticals or scenarios you may have seen yourself in where you just want another perspective or just an open discussion on it. But at any time, if you do have questions while we're going through it, please let me know. Whatever's easiest for you so we can address that. But today we're going to talk about the sticking points in the RAIN contract. We're all familiar with that RAIN contract. Some are pretty boilerplate template language, and then some are kind of open to interpretation, and that's where a lot of the negotiations come into play. So my camera's here, my presentation's on my other screen. I apologize if it looks like I'm not looking at you, but I just want to make sure I'm on the correct slides. So we will get started without further ado. So just to start out, create a good basis and a fundamental foundation for us, contracts. So statute of frauds requires contracts for the sale and transfer of land to be in writing. Now, like a follow-up to this is sometimes we have conversations over the phone and it was like, yeah, we received the offer via email, we're going to accept it. So over the phone, that's verbal, right? So is that a legally binding contract according to the statute of frauds? No, because it needs to be in writing. So just keep that in mind. A lot of people say, oh yeah, well, you know, we're going to get to it. We've accepted the offer, but you want to immediately follow up with the transmittal of the writing, because then in the legal sense, there's wiggle room if another offer comes in and it comes in writing versus your verbal acceptance. So just keep that in mind there. There's 3 elements to every contract. There's the offer. There is the essentially one of those things where if the offer is accepted and there's consideration, then it's a binding contract. But if any change is made to the offer, so even if it's like, hey, this looks great, but can we just move the closing date up to this date? That is technically not an acceptance of the offer. That is a counteroffer. There has been a change. So you have to take the offer as it is with no changes. Otherwise, it's seen as a counteroffer. And a counteroffer is a rejection of the offer and essentially a new offer. So just keep that in mind. If you do make one change, essentially, and anybody could walk because it's not an acceptance. And then there's that acceptance we talked about, has to be identical. Nothing is changed on the document. And then consideration, some value in exchange. So usually it's money in exchange for the property. That's what we often see in real estate transactions. So example 1, we have a buyer that will give you $250,000 for your house. Seller accepts. Is this a contract? Yes, because we have that offer, the $250,000 for your house. There's an acceptance of identical terms. Nothing's been changed. And there's mutual consideration, right? I'm going to pay you money in an exchange. You're going to give me the house. So that's perfect. Kind of highlighted all those terms there. Another example for you guys to volunteer if you have the answers to it. Buyer says, I will give you $250,000 for your house and close in 30 days. Seller says, I accept your offer, but need to close in 20 days. Is this a contract? I kind of touched on it. So we have an offer. Do we have an acceptance?
No, it is not a contract.
Bingo. Yeah. So it's a rejection and a counteroffer. Like we talked about, you need to accept the offer in its identical form. Here, they changed the closing date to try to move it up 20 days earlier. So this essentially is a new offer or a counteroffer. We already went over that. All right. So now going into like the meat and potatoes of the RAIN contract, deposits. So here, this is a little snippet of what the language is in the RAIN contract. You have the contract that's signed and ratified, and the EMD will be delivered, right? So according to this document, not delivering an EMD is actually a breach by the buyer and can cause grounds for termination. You will see in this document that in the second paragraph, I don't know if I have a highlight tool here. Let me see. Can you see my mouse on the screen?
No, we cannot.
No, okay. All right, so in the second full paragraph where it says buyer with a check mark has paid the deposit to the escrow agent or will deposit, you'll see within 2 business days of the ratification date. So this essentially means 2 business days. If you close, or if you go under contract, you ratify the contract on a Friday, Saturday is not considered a business day. So then you move to Monday, and then you move to Tuesday. So you have to look at the business days. It's not calendar days. So that's a big highlight there. And then what technically constitutes delivery of an EMD? What is the receipt of the EMD within a timely fashion? It's either physically dropping the check off to the escrow agent that's indicated in the deposit section. It is wiring the money and showing that the wire has been received. It is a debit transfer where the money has been initiated to transfer and there's a recipient of those funds. Now, here's one thing that some people get hung up on is taking a picture of the written check that says, EMD for the purchase of XYZ house, and it's for $2,000 and it's a picture and it's sent. Is that actual acceptance of the EMD, which is timely delivery? I see all of you shaking your head, which makes me so happy. That is correct. It's amazing how many times people think that is timely delivery. Now, of course, a lot of times that will happen, and then they'll follow up with actually bringing the check the next day, and that is essentially curing the default. It's not a substantial issue, and a lot of people will be okay with it, but it's still not timely received, which can be grounds for someone to terminate and walk. This is important with the EMDs because if there's ever a multiple offer situation and we all know it, maybe you have a conventional loan that was more favorable to the seller over a VA loan, even though the VA loan might have been a little higher. Well, if you don't get your EMD in, they might think, well, they're not going to take this seriously. I'm just going to go with my other offer, and they can walk based on that 2-day period of time. And so we do see this, although it's just an EMD, it is one of those things where people can hang their hat on it and get out of the contract quickly if it doesn't occur. So just keep in mind, although it's not always a huge thing to people, it can become a huge thing. All right, let's go back here. So, is there an enforceable contract if the buyer fails to make the deposit? We already kind of touched on this. No, the seller can go ahead and essentially terminate, right? We talked about this because there is that 2-day period of time, business days to be exact, that they need to go ahead and go forward. Now you will see there's a 3rd paragraph down. If buyer fails to pay the deposit set forth above, or if any check or other funds by buyers are dishonest or dishonored, escrow agent shall properly provide notice to the buyer and seller. That could be seen as breach of agreement, and the seller may terminate the agreement by written notice to the buyer, in which neither buyer or seller have any further liability. So it says it plain in black and white writing in the RAIN contract. If that money is not received, then the seller can go ahead and terminate. It has to be in written notice, though. I want to highlight that. So again, not over the phone, and just by virtue of default from a legal standpoint, having things in writing is always better. Even if it's not required to be in writing, if it would ever go to court, at least you can substantiate and have that evidence of, hey, here's proof that this communication did occur, instead of it turning into a he said, she said type of thing. But here there is a requirement clearly set forth that that termination needs to be in writing, which there's a RAIN document that's, pre-formatted language about a termination you can just use, and that could be your written communication as well. All right, so escrow agent. The deposit shall remain in escrow until settlement or termination. In the event the transaction does not close, escrow agent shall hold deposit in escrow until 4 different things occur, and they're all independent. So only one thing needs to occur. Buyer and seller have agreed in written agreement as to the disposition of the deposit, and the deposit shall be returned to the agreed upon party, provided in such written agreement, and that will be set forth in your release. So there's terminations and releases, right? Terminations could be unilateral. Releases have to be signed by all parties involved, and releases generally address how the EMD will be returned. And in there's again pre-formatted language that states essentially upon the parties signing this document that each of the parties will waive their rights to pursue any further damages. If you ever have a situation where you want the return of the EMD, but you also want to reserve your right to potentially demand mediation or sue, you will need to be mindful and actually redline or line out that pre-written language. And in doing so, because you're removing language, you'll need everyone's initials on it. And so that kind of is a flag for the other side to be like, oh, well, they're trying to reserve their right to sue us, well, we don't want to give them this money, but that release needs to be signed by all parties, and then the escrow agent can go ahead and disperse the funds based on what that release states. If we don't have that release, then the escrow agent can't do anything because there needs to be a meeting of the minds on it. So then we go to Roman numeral 2, the deposit is successfully interpleaded in a court of competent jurisdiction pursuant to this section. Interpleading money essentially is one of those things where us as escrow agents have the money. There's two parties in dispute about where the money should go. We give it to the court and say, hey, we're not involved in this money. Once there's an agreement or a court order, the court can go ahead and direct it to where it needs to go. So we essentially will remove ourselves from liability. So if there's ever a big dispute about it, we can go ahead and put it in the courts, and then the court can go ahead and make a decision based on the parties' arguments, and if the parties go ahead and seek court intervention on that. If we don't interplead the money and we just hold on to it until the parties figure out what they want to do, we got a Roman numeral 3, a court of competent jurisdiction orders such disbursement of the deposit. So this is when someone would go ahead and file suit in court. Now there is a paragraph within the RAIN contract that requires mediation first. So to be in compliance with the contract, we want to go ahead and do demand for mediation, ask for their available dates in the next 30 days. If we don't get a response, then we can go ahead and pursue this next avenue of suing. But we don't want to put ourselves in a potential breach because we didn't follow what we contracted to. And if those three things don't work, then there's always the option for the escrow agent to utilize their own discretion and release the deposit to the principal to the transaction who's entitled to receive the deposit in accordance with clear and explicit terms of this agreement. So you can always have in other provisions in the RAIN contract, regardless of the reasons why buyer may want to terminate, EMD will always be returned to seller. If everyone agrees on that, everyone agrees on that, right? And so that is a clear term in the contract, provided that everyone signed the contract and it is fully ratified. That explicitly gives us direction on where those funds should go. There's also sometimes in the contract where it states, if there's a property owners association, a condominium association, they being the buyer has 3 days to review those documents, and they can terminate and walk away at any time. There's clear language about where the EMD is going to go with that. So there are clear language that give us guidance where we can use our discretion to go ahead and disperse. So those are kind of the ways where we can disperse. But the big thing is what we often see are signed releases by all the parties instructing where that EMD is going to go. All right, when can a deposit be released? So we touched on this as we went through that, but an agreement in writing with the buyer and seller, which is that release, interpleading to the court, which again, we send it to the court and then it compels them to go and litigate and get a court order. It could be ordered by the court and we can still retain it until we get that order and then disperse, or the terms of the agreement will govern. Can an escrow agent make a determination on the disbursement of the funds? And we just went over this up above, so you'll see the clear and explicit terms of the agreement. Yes, but we're not required to, right? I kind of use the word discretion. It's up to our discretion. So a lot of times people are like, oh, well, like it clearly states that, just do it. But as escrow agents, we have fiduciary duties too. And so if we don't feel like it's clear and explicit in terms of where that money is going to go, we don't want to then essentially expose ourselves to liability, or the agent's to liability, or even our client's to liability if ultimately that disbursement was incorrect. Or if we get notice that essentially there is contention and there's not an agreement on this, even though the clear and explicit language may look like it's there in the contract, it's always up to interpretation. And so if someone puts us on notice that there is not an agreement, then that is one of those things where we would probably want to hold the funds to until we can get a clear agreement. So then let's go on to loan denials. Here, loan denials are a big thing, right? Some people think, oh, this loan denial was not real. It was actually something that was, fabricated by the lender because there's another underlying reason. But a loan denial is a loan denial, right? We're not sitting in the shoes of the lender, so we don't know what risk the lender is willing to take. And that is kind of the fundamental basis for a loan denial. But there are some requirements here. If buyer's loan or assumption application is denied, buyer shall, within 3 days of any communication of denial to buyer, provide written notice of such denial to seller. So here we talk about, written and oral. Again, very explicit. It needs to be written notice of the denial. And we talked about calendar days versus business days, right? 2 business days for the EMD. Here it says 3 days. Since there's no explicit indication that it is business days, this is 3 calendar days. So Saturdays and Sundays count in this. And you'll see this is if buyer's loan or assumption application is denied, buyer shall within 3 days of any communication of denial to buyer. So that means the lender could verbally communicate, hey, we're going to have to issue a loan denial because your debt to income ratio is too high, whatever may be the reason. But that is a communication. It doesn't say written communication. It doesn't say formal letter on lender's letterhead communication. It says any communication. So really technically to be in compliance with this, if you do get a verbal, you have to pass that along. And you passing that information along has to be in written form. You'll see it's set forth in this paragraph B here. So just be mindful of that. And then upon the request, you can go ahead and provide that denial to the seller if it's reasonably requested. You'll see there's language in there right there. They want documentation just to confirm it's a valid loan denial and it's not something where you're trying to get out of it. So these are where you see it a lot. There's fights over it. You know, there's a lot of times in loan denials too, you'll see in VA loans, and this is coming up more frequently. So I just want to kind of highlight it for you. But in VA loans, a requirement of a VA loan is that this will be the primary residence of the veteran. And if you don't have orders here, or if orders all of a sudden come that take you somewhere else, there's a lot of back and forth about if those orders are actually temporary orders, if they're permanent change of station orders, what those orders are, and if those orders were created just to get out of the contract. So anyway, a lot surrounding that. But again, going back to loan denials, that is a requirement of what the lender is. And if the lender is not going to issue the loan because they don't think this is going to be the primary residence, unless we're going to go and audit the military and then go ask why the lender is not willing to take the risk when they already saw, you know, orders prior, that's just a tall task. And that's assuming a lot of things that people weren't being honest in the transaction. But again, from a loan denial standpoint, it's more of the lender and what the lender's willingness to do is. A loan denial is a loan denial. So just to highlight that, a lot of people, again, and I feel like I have 4 or 5 cases with this right now, so that's why I'm kind of honing in on it. But our position is, again, a loan denial is a loan denial. We can go down that rabbit hole if it might be fabricated, but at the end of the day, if it's signed off, and if you have that letter from the lender stating it was because this isn't going to be their principal residence, there's a lot of protections, service member affidavit, and orders of that regard too. So just want to highlight that. When must buyer communicate denial to seller? It was highlighted in that paragraph. Does anyone remember? So
Angela is
No more than 3 days.
Angela was signaling.
Yes. So you're right, 3 days, and I highlighted this, but any communication. So again, that's oral, written, whatever may be. And then you are responsible to communicate to the seller via written notice, right? And we kind of touched on that. And then again, upon the request, the lender's denial notice that you can go ahead and send to the seller if they do request it. And that's the just little indication there that we already went over here. Now, we touched a lot of loan denials, and a lot of people will hang their hat at, well, this is a bad faith denial. What exactly is considered a bad faith loan denial? We'll do some examples to kind of play this out, but example 1, buyer receives loan denial and sends denial letter to the seller. Denials because of failure to obtain lease on a different property. So here, there is a clause in the RAIN contract, section 7A, that states purchase is not dependent or contingent upon sale, settlement, lease, or refinance of other property. If this contingency occurs, well, then you need to go ahead and remove that language, because the way the language is pre-written in the contract states there's no contingency. It's not contingent on these things. But if you want a contingency to exist, then you need to remove that language. If that language is not removed, then technically when the buyer and seller entered and ratified the contract, the buyer is representing that, hey, it's not contingent upon me getting the lease on the different property. And now all of a sudden this has become an issue. which shouldn't be an issue because it should not be a contingency, right? But the lender is saying, no, this actually is a contingency. So it's not in good faith that the buyer entered into this this contract with you because they knew that this was a requirement that had to occur before they could go ahead and qualify for the funds. And here's the little paragraph 7A. Yes.
So just for clarification on this is only if it's not written in the contract. If it is contingent on the home sale or lease or whatever, and that part is written in the contract under other contingencies, we don't have to mark through this, or is it best practice to do both?
Great question. So I would say it's best practice to do both so that there's no ambiguity. There's no reason to say, but that was still in there. Why didn't we remove that? That's my personal opinion. From a legal standpoint, it's often seen as any written language, so handwritten language or language in addition to what is pre-formatted on there is, I don't want to say superior, but supersedes what that template language is. So if you did add those additional clauses about this is contingent on the home sale or this is contingent on this, arguably that would supersede this written section 7A. But again, I say arguably because we're in court a lot with those things. Well, if they truly meant that, then why didn't they cross that out? Or these are in conflict with each other and that written was included before the typed. And so does the, next in line or the last in line actually reign? And, there's people always arguing about everything. So that's why I would just say to remove any question of it, I would actually remove that section and add your language about this being contingent on X, Y, or Z. If you don't do that, that's fine. Like I said, because the general legal consensus is any added language is actually the superseding language, but hopefully that answers your question. All right, and then another example. No contingency stated in the contract, but buyer desires to use funds from sale of residence to fund purchase. Buyer does not close on settlement date because of lack of funds, but liquidates other assets to fund the purchase within a 10-day window. Are buyer's actions considered a breach of contract? Now we see this a lot. This happens a lot. People don't want to put contingencies in, especially with how the market had been, because they don't want to make their offer look less competitive. But a lot of times it's the domino effect. They're trying to sell the house, get the funds from that house to apply to the purchase of the new house. And then something's delayed on this transaction, which then delays this transaction, right? But there was no contingency. So technically, no one needs to wait for this transaction. Lender has clear to close. Everything's good. The 10-day window I'm talking about is obviously that, title defects or loan issues. Well, here there's no title defects or loan issues. It's just the buyer who said they have the money, not having the money at the time of settlement in the contract. So technically this is potential for damages, right? Because there was no contingency mentioned in the contract. And then all of a sudden now there's this issue. But at the end of the day, what we often see are people just waiting and falling within that 10-day window, even though this technically doesn't fall under the 10-day window, because the hassle it would take to go under contract again and the time it would take. Sometimes this, 2 to 3 day delay is something where they're like, okay, fine. Now, in these circumstances, though, there's definitely grounds to try to negotiate. Well, I at least want an additional $1,200 earnest money deposit, non-refundable, because if it doesn't close in 3 days, then we're going to walk. Or so you can put terms on it and you'd have negotiating power to do so. Because again, from a technical standpoint, this is a breach, right? It doesn't fall under any of the reasons to do the 10-day extension, and there is no contingency. So
if he argues that it is a loan issue because the buyer can't get the loan without those funds, so could it be argued that it would be a loan issue?
Well, I would say no, because the lender went ahead and issued the loan. They had the clear to close. Everything's good in terms of the lender. There's not an underwriting issue. There's not a need for verification of funds. There's nothing like that. That all occurred, right? And then we get to the date and it was like, oh, well, me and the contract said I would have liquid funds by the date of closing, and I actually don't. So that's a buyer contracting with terms that they said they would have when they didn't at the end of the day. So my argument would be, no, this is not a loan issue because the lender did everything and we're ready. We all are ready to close, have the package here at the table. It's but for the buyer having those funds that it's not closing.
So would it be the same type of thing as if a buyer was waiting on a gift for closing cost assistance from a family member and that family member had not yet gifted them the funds?
So that's a great question. And we've seen that too. If those gift funds are disclosed in the contract, or if those gift funds are part of how the debt to income ratio is working out for the balance of what the loan is going to be, then that could be a loan issue, because, and you see this too with lenders requiring debt pay downs. You see this with lenders requiring those gift funds because their debt to income ratio only allows them to loan a certain amount and they need that extra to accommodate. So that could, in that situation, be seen as a loan issue. Now, if it's one of those things,
contract, right?
Pardon?
But only if it's put in the contract.
Right.
Or if it was part of the debt to income is what also Lindsay said. So if the lender is aware and has it in their paperwork, it doesn't have to be in the purchase agreement that they're receiving these funds.
Right.
If you guys have never been to Stump the Broker, by the way, I warned Lindsay ahead of time that this is what this call was going to be like. So you guys, please, every time Jordan unmutes herself, I get excited because I know she's going to say something great. So you guys feel free.
They're all wonderful questions because we see it play out a lot. Like, these are real life scenarios that you could potentially be in too. So I'm so glad she's asking, because it happens all the time. Or you have some family members, that like, promised those gift funds and the last minute was like, oh, actually, I realized there was a penalty to take out money in my IRA and I don't want to do that anymore. And then you totally have to either recast the loan, or you realize, oh my gosh, now I'm not going to qualify, or you yourself never had those liquid funds and you were depending on them, and now you're at a place where you're potentially putting yourself in breach unless it is a term of that loan.
Yeah. So if you guys have, if either of you have ideas, I know a couple people have like, we haven't gotten any questions in the chat, but you can definitely put your questions there and I'll read them, or just feel free to kind of chime in when you're able. But if you guys have never been to Stump the Broker, this is how all of these are, and I absolutely love it. So I'm excited we're doing this.
Yes, yeah, absolutely. All right, here's another just kind of example, and this is where, you try to have faith in humanity, but sometimes people just are bad actors. But buyer realizes that she doesn't want to move forward with the purchase. They purposefully don't make one or more credit payments, thereby hurting their credit. As a result of credit hits, buyer no longer qualifies. So here it's one of those things where, is this a bad faith loan denial? Well, how are you going to prove that they purposefully didn't make their credit payments? And this goes to intent and motive, and those sometimes are really hard to prove. Now, if you, out of the principle of the matter, say, you know what, they knew that they were under contract and they knew credit was going to be run and they knew they had to dot their I's and cross their T's. And even if it wasn't intentional, it was still negligent and they didn't act in good faith to consummate this transaction, and you wanted to go forward and stick it to them, you absolutely could, but you'd have to demand that mediation, and then it would probably have to go to court. And it's always one of those things, not that I discourage court, like I happen to love it, but it's really the best interest of the client, right? And it's the cost benefit analysis and how much money do you want to pay out to see if you even recoup that money. There's always, demand for attorney's fees and reimbursement of costs and damages and all that stuff, which is great, but you have to front the money to get to that point until you get that order. And going to court is always a subjective thing because judges are human, right? They base on the law, but they have different interpretations. So there's that aspect too. So I always try to educate the clients of like, hey, this is great, and here's all your options, and here's all kind of the fallout from it. What would you like to choose? So there's that aspect too, where again, you've got good arguments, but at the end of the day, I mean, what are you going to do? Like, how much money are you going to invest in it? Or are you going to turn around, just do another 30 days and get under contract with someone else? All right, seller representations. Here we go. Except as expressly provided below, seller represents that seller owns good and marketable fee simple title to the property, has the right to transfer the property without obtaining the consent or approval of any other party, including without limitation judgment creditors, lien holders, or other lenders, or any court, including bankruptcy court or court having jurisdiction with respect to the distribution of marital property. So I just want to stop here under that Roman numeral. You have a lot of things here. It says they don't need approval or consent from any other party, right? And then they highlight a couple big things. They highlight bankruptcy court, and they also highlight distribution of marital property. Those are two things I want to highlight on, because If the party is in bankruptcy, you do need the approval of the bankruptcy trustee to be able to sell a house. If we don't have that bankruptcy trustee's approval, then we're at a big halt. So if the property is under bankruptcy, you're going to want to hone in on this paragraph and essentially make a note that states this is in bankruptcy. Bankruptcy trustee already approved the sale. Court order will transmit upon ratification, or somehow make a note that here there is the need for approval. The approval has already occurred, or the approval is in process. Same with distribution of marital property. This is one of those things where sometimes marital property could get tied up in court, right? If they're arguing over that marital asset, well, you don't want the parties to go ahead and sell it. And if they do sell it, what are you going to do with those funds? If there's not an agreement on the disbursement of the funds, then you're going to have to hold it in escrow. Now, if you have that escrow agreement, that's fine. But then when there's divorces involved, usually there's divorce attorneys, which are separate from the real estate attorneys. So then you want everyone to be on the same page. You don't want to do anything that would essentially prejudice your client in their divorce matter. But without either a copy of the fully signed separation agreement or the divorce decree, or communication affirmed by both of the divorce attorneys that this is how the thing is going to go, then you do have to be mindful of that, because in divorce proceedings, there are interim orders, there are pendente lite orders that states, no parties will destroy or disseminate or go ahead and sell marital assets. Well, if that's the order in effect, then technically they can't sell the asset until there's another order stating that they can. So just to be mindful of that, if you do have parties that are going through separations or divorces, asking if they have any agreement on the disbursement of the funds of the sale or even the sale itself would be really important. So I just want to kind of highlight there. And then also where this comes into play, short sales, right? When you have a short sale, you need the bank approval. So that is needing the consent or approval of another entity. So these are important here to note if you've got those at play. Otherwise, they're essentially stating, nope, I'm owner of the property. I can sell it, no problem. What does the seller represent by signing the purchase agreement? And it was highlighted in those representations in that little paragraph we just went over. But essentially they own good and marketable title, and then they do not need the consent or approval to sell. So that's what they're representing. They also, and we touched on this in a prior example, but that they have sufficient cash to close on time, right? So we touched on that. They realized that they didn't have the cash from the sale of their home, put them in that 10-day window. Well, if these aren't lined out, then they're representing, no, I already have the cash, we're good, we can close on time. So right here, the last one, seller will be in a position to transfer title to buyer free and clear of all liens, leases, and tenancies, of course, except as agreed if you're going to take the property with existing tenants. And then that paragraph again that we talk about, the one thing about having the available liquid funds, I do want to read Roman numeral number 3, if necessary, has or will have sufficient cash or other liquid funds to make any payments required to be made in order to pay all brokerage fees due to transfer of property without any liens attaching to the property. So here, a lot of times sellers are like, I'm selling the property, I'm going to go ahead and make a profit. The equity in the house is great, but you have those sellers too that every now and then need to bring money to the table. And in this section C right here, the seller's representing, if I need to bring money to the table, I have those liquid funds. It clearly says sufficient cash or other liquid funds to make payments. I can't tell you how many times when sellers are in a position where they need to bring money to the table, they say, I never knew that. I never had a net sheet. I never saw what my bottom line was going to be. That's impossible. Sometimes you have people who think they are going to, net a certain amount, and then all of a sudden there's a judgment from 4 years ago that's for them, and they need to pay it off, and now it puts them to, bring $2,000 to the table, and they say, I don't have that. And I don't mean to sound callous about that, but I essentially tell them, I was like, listen, this puts you in breach. It's clear as day in this document. You said you would have the money if you had to bring it. I would suggest going to your couch and getting all the money and that fell through the cushions, asking for a family loan, doing something like that. And I was like, if you don't have the money, you don't have the money, which I get. And I go ahead and convey that to the other side. But the legal ramifications are they could potentially go ahead and try to find you in breach, demand mediation. It could potentially go to court. We could try to release, give them the EMD, play forward all those. But here you'll see clear in writing in the RAIN contract, it actually states that the seller will have those funds. So if you, best practice would be to do a seller net sheet, obviously say it's estimated and dependent on what the numbers are at the time you do it, because that always changes. But it would be very beneficial for you as the CYA too, to also give them that net sheet. So if it comes to turn out that they owe this money, you could say, well, you knew you were only going to net $500 and this was not with the knowledge that you had a $2,000 judgment, you know. So it's one of those things too, where they kind of had a heads up, hey, there's not a lot of wiggle room here. Now, if they're going to net, you know, $450,000, it'd be a total another side. Yes, Angela.
Yeah, I want to ask, can you hear me?
Yes.
Okay, I can't hear you guys. Hold on, bear with me. I want to know whether or not, in this, when you do this seller net sheet and you tell them that they have to bring a certain amount to the table, do you think we should have them sign it and give them a copy of that net sheet? Jordan.
Yes, 1000%. Yes.
waiting for
Lucy and I are
Lucy.
screaming yes.
Yeah.
So yeah, great question. The theme throughout here, right, is try to get everything in writing. And you have that in writing, you provide it to them, but they can always claim, oh, I never got it. But if you have a copy with their initials or with their signatures on it, and I would even go far as to have them date it, to say, hey, I gave this to you and you acknowledge that you at least put eyes on it. You know, unfortunately, again, estimated net sheet, right? It was based on what we knew at the time, and this was kind of the best I could give you. We can always do an updated one, but at the end of the day, you knew what it was looking at with what numbers we had in there. And if we added this judgment in, which is something that is a defect on title that you are responsible for clearing in order to convey that fee simple, clean, and marketable title, these are just what the numbers are, you know. And it's one of those things too, where I would really impress upon you to use your discretion. Ultimately, at the end of the day, it's your decision, but there's those circumstances where then they're going to lean into you. Well, can you take a cut of your commission? Well, can you waive your admin fee? Well, can you do this? Well, you can do that. Well, that's how you guys get compensated. And a lot of people see that, but don't see that, right? Because that's before taxes, that's before paying for everything. And so if you want to do that, by all means, that is an option to you, but don't feel like that is a requirement to save the deal for your seller when your seller hasn't made the best educated decision for themselves, because you can only deal with what you know. And as long as you know you're doing a good job to advocate for your client and provide them the information that you can with what you know and with what you can gather based on public records, then I'd say job well done for you. So that's just my little nudge there, because I often see commissions that are cut, but at the same time, that is your income too.
Can I make a question?
Yes.
I apologize if I don't do the question properly, but if the seller doesn't have the money to pay, you know, for the closing costs and the property is sold, can those closing costs, that balance can be reduced from the payment, you know, once the house is sold?
So she's asking, if the closing cost that the seller is going to have, can that come out of close? But I think in this situation, what we're looking at is maybe a property that's more or less underwater, where they're not going to be making any proceeds on the house at closing.
It's a very new concept for a lot of the agents who've only been practicing, you know, since 2019, 2020, where a lot of times, you know, before then, sellers would have to pay to get out of their house. There was not automatic equity. So it's not something we see often these days, but it is coming back where, you know, it makes a net sheet even that much more crucial as far as what are you going to be making, or do you have to bring money, and how close are we? How tight are we going to be? It took me years of being in real estate before I saw one of my sellers like make more than $5,000 profit on selling their house. Years.
And another example of this would be if someone is actually going bankrupt, which Lindsay, actually, if you can speak on this, because I've seen this before, where if say the seller has filed for bankruptcy and actually in this situation, the person thought that they had filed, but actually had never completed the application and was under the impression that selling the property was going to more or less wipe away a lot, like those had already been wiped away, and it was a considerable amount. I mean, over $10,000 worth of condo dues and those types of things as well. So Lindsay, if you don't mind, just, I know that's not exactly, but it kind of does relate into this because we're talking about those liens and stuff like that. Will you kind of clarify what is wiped away, which isn't really a true statement, but what's wiped away in a bankruptcy?
Yes, absolutely. So the bankruptcy proceeding goes through bankruptcy court, and there's a bankruptcy trustee that's appointed. The bankruptcy trustee essentially has the discretion based on creditors going ahead and requesting payments or non-payments or negotiation payments, whatever may be the case. But essentially of wiping away, to use Christy's words, any personal liability on debts. So if you go through bankruptcy and they, wipe away your debts, it's personal liability. And this is what a lot of people don't realize. Even people who go through bankruptcy, it's only your personal liability to the debt. That does not strip any debt that's associated with the property. So let's say you have a credit card and you didn't make payments and it's $7,000. Well, that bankruptcy will discharge you from the personal liability of paying back the $7,000. But that credit card company could attach it to the property you own. And then once you sell that property, that will need to be paid off through any equity in the property before you get any proceeds to yourself. That is a lien that attaches to the property. Bankruptcy only discharges personal liability. It does not strip liens to the property. If you are in a situation, and I say you, but like clients are in a situation, their bankruptcy attorney will need to file a motion to strip liens in order for that to be removed from the property. And that's where a lot of people, like Christy was saying, like, oh no, I went through bankruptcy and they totally discharged or wiped away all my debt. Like I'm free and clear, everything should be good. And then all of a sudden they have this credit card debt. They have this outstanding car payment that's associated. They have
IRS.
Exactly, IRS debts, all that stuff. Those are liens on the property. And if that motion to strip was not made and not granted in the bankruptcy court, then those are still liens that the seller is responsible for paying for. And that does come up quite a bit, where there's, I don't know if there's just not an education in the bankruptcy proceeding, or if they're just so excited that at the time they hear, okay, we're discharging you of your debts, they don't see it all the way, or there's that disconnect because they're only dealing with the person and not actually the property, or whatever may be the case. But yeah, it's just the personal liability. Now, if they get discharged from personal liability and they live in that house until they die, well, then their estate might need to take care of the debts, but sometimes debts die with the person. So that's a whole nother ballpark. But if you do stay in the house, you won't have to pay for it. It's only when you essentially move from the house or you pass on and the estate is subject to those. Does that answer?
May I add to that?
Sure.
For the last 10 years, I worked for Require. So every time we go to clear title, there's always someone saying, oh, why do I have, because we're going to go try to get a discharge for an old unreleased mortgage or IRS, whatever it is. And it always comes up, they owe, 80,000, 100 something thousand. And they thought that it was discharged, but now the bank let it go for all these years, but you're going to sell. So here's your balance due. So they're shocked that they owe $100,000 thinking it was discharged, but it really wasn't.
Yep. Yeah, that happens a lot. Now with the IRS liens, I see them infrequently, but it's not a rarity, if that makes sense. It's also not a regular thing, but when we do have big IRS liens, we always try to negotiate them. Now that's a whole separate retainer outside of what our settlement fee is, but if the IRS lien is actually more than the equity of the house, we try to get a lien in compromise so that they accept whatever equity is there in full and final satisfaction. So we do try to approach that too. So that's something that won't then follow them in the next transaction, or essentially lock them up to not be able to consummate this transaction. But yeah, it's unfortunate. That is a very common thing though. All right, I'm going to move along unless there's any other questions. Okay, so Estate sale without signature of every heir, limited liability company sale without signature of authority, improper net sheet calculations leave seller owing too much money. These are all examples that we see in terms of seller representations that kind of create issues, right? Because in an estate, excuse me, every heir is considered owner of a property, even if it's 1/8 owner, if it's a 50% owner, if there's 2 heirs, they're considered owners of the property. So they all need to be on board to sell the property because they all have a distinct ownership interest in it. If you only get 7 of the 8 heirs to sign the document, then only 7/8 of the property is actually being conveyed, but you are conveying that whole unit. So that's why you need all of the heirs to sign it. For limited liability companies, if you have someone that's not in authority to sign on behalf of the limited liability company, then technically the limited liability company is not under contract because it's not the right person signing for that company. So it's really important to kind of parse out who has the authority to sign. Now, if they're single member LLCs, that's pretty simple. You do a resolution just saying I'm sole and single member. I'm the only one that acts on behalf. If there's multiple members, sometimes there is a manager designated, and the manager within the operating agreement has clear authority to go ahead and sell and encumber and do all the things. If there's no operating agreement, and this gets into kind of business formations, but in Virginia, you're not required to have an operating agreement. So sometimes there's no document that sets forth who has the authority to sign. In that regard, at settlement, we would have what's called a resolution. Every member of the company would need to sign the resolution that essentially states they're all members of that LLC and they empower person X or person X and Y to go ahead and sign any documents pertaining to the disposition of the property. So there's that aspect there too. And then we talked about improper net sheet calculations showing that seller owes too much money. Those are, pardon?
I have a question. No, keep going, but I have a question.
Do you want to ask it now?
Whenever you want, just keep going and let me know when I can ask.
No, go ahead. Yeah, you're good now.
Okay. Long story short, my husband and I bought a house 50-50, you know, we were owners 50-50. I bought his part and we made a bill of sale, you know, it wasn't in the public records and his name was still on the property. If I want to sell the property and he doesn't want to sign, you know, in order to sell, for me to sell the property, do that bill of sale works? Is that legal? No. Okay.
I mean, in terms of like transfer of money for the ownership interest, but I would have to probably put eyes on the bill of sale to give you a precise answer for that situation. But from what you've shared with me, if you're both still on title, then you're both owners of the property, you're title holders of that. And so whoever's on the deed, whoever's on title will be the ones that have the ownership interest and have to go ahead and convey that. Now, a suggestion, and again, this is with the limited facts you gave me, but a suggestion would be for him to go ahead and deed his interest to you so that then you're the sole owner and then you just have to sign everything. If he's not willing to cooperate, you'd have to look at that bill of sale to see if in there you said in exchange for the payment you gave him, he was going to convey all his right interest title in the property. So you would want to look for that language too. But again, that's just limited to what you just shared with me. To give you a better guidance, I would need to know more. But hopefully that gives you at least a path going forward.
No, that happened like 5 years ago, but you know, it was just a scenery. Then I was wondering if a bill of sale works in that case, you know, because his name is still in the property taxes. Right. You know what I mean?
Yeah, so his name's in the property taxes because he's still on that deed. So in terms of public record, he is owner.
Thanks.
Okay, so let's just go really fast over this because here we get into a lot of issues too. So this is contingency removal, release, and deadlines. All right, so here you essentially can put whatever days within ratification of the agreement the buyer will deliver to the listing firm an entire copy of the inspection report together with a PICRA or a release and or a termination. Right, terminations are unilateral. This just states, hey, we're terminating the contract, but then the release usually follows with the disbursement of that EMD in the agreement. So here we're going to go ahead and jump down to B because this is what I really want to highlight. BI, the party shall have 5 days after buyer's delivery of the proposed removal addendum to negotiate and agree upon the removal addendum. At any time during the negotiation period, Buyer or seller may make, extend, or alter offers or counter offers as desired to finalize that addendum. If buyer and seller agrees upon the terms, the party shall execute the removal addendum. So that's a 5-day negotiation period. You can go back and forth, you can make counters, you can make revisions, you can make changes, you can make concessions, whatever you want. A counter doesn't mean it's dead. You still have that 5 days to try to figure out and meet in the middle. Number two, B, oops, sorry. Ooh, what did I do? B, number two, if the parties have not executed or acceptable removal addendum prior to the expiration of the negotiation period, buyer shall have the option to terminate the agreement by delivering a termination notice to seller within 1 day following the expiration of the negotiation period. That's considered the additional day. So here, I just want to highlight that. So essentially, buyer has, right, 6 days to go ahead and release or terminate. You have that 5 days to negotiate, and then if nothing occurs, then buyer on the 6th day can go ahead. Yes, Jordan.
So if please finish that thought, and then I'll ask a question.
Okay, yeah. So on the 6th day, the buyer has the right to go ahead and terminate, right? And then we're following after the expiration of that additional day. If buyer has not accepted the terms agreed on to date, removed the contingency or terminated the agreement, then either party can terminate. So the buyer has until the 6th day to go ahead and terminate or agree that no picker items will occur and they'll just take the property as is. And it's the 7th day that then the seller can terminate. So a lot of times what we see here is the 5-day negotiation period occurs, and then all of a sudden there's no agreement reached. And then the next day, the seller goes, well, here's a termination and release. But based on how the language is in the RAIN contract, that 6th day is the buyer's right to act. So that 6th day still allows the buyer to say, you know what, I'm removing all contingencies, I'm taking the property, let's continue forward. And so even though the seller has sent it on the 6th day, technically that is not timely. That does not allow the buyer to exercise their right to utilize that 6th day to make their decision. So the seller really on the 7th day can act. And I know that's confusing, but the negotiation period is where you're just trying to reach a resolution. And that's that 5-day period, right? So you have 5 days. After that 5th day, then the buyer can be like, you know what, I thought about it. I just really want the house. It's not worth this. I'm going to remove all the contingencies. They can do that on the 6th day. That does not need to occur within those 5 days. That 5 day, again, is that negotiation to see, well, are you willing to do 1, 3, and 5, and then I'll waive 2 and 4. Okay, I know that you don't want to do that, but will you give me a closing cost assistance in lieu of repairs? You know, so that's the negotiation. It's not just the, I'm going to remove it all. I'm going to act as though there's, you know, never been a PICRA or anything like that. So that's where a lot of people kind of get stuck, right? Is that 6th day wiggle room, and sellers acting on that 6th day when technically they need to allow the buyer to act on that 6th day, and then the seller can go ahead and terminate on the 7th. A situation where this might come up is, you know, the parties have agreed on everything but one repair. The buyer may want to go forward and negotiate that one more repair, but the seller's just not on board. Well, come that 6th day, if there's not an agreement on it, then either the buyer can say, you know what, I'm removing that, that's fine. Or if they're still trying to negotiate that additional repair and nothing is reached on that 7th day, the seller can be like, well, you know what, we don't have a fully ratified PICRA. I'm going to terminate and release. Jordan, go ahead with your question.
So this came up recently. So when on paragraph I, so BI, it says the party shall execute the removal addendum. Who are the parties in this, and does the ratification box on the PICRA matter? Because the way that I read it and interpret it is the buyer and seller are the parties who have to agree. And if, as long as that's fully signed, it would be considered ratified, and the agent is just putting the ratification signature on there. But is the agent's ratification signature a crucial part to make sure that that PICRA is ratified? Or if that agent's signature isn't on there within those 5 or 6 days, is it really ratified? And could it be then go back and say, no, it's not ratified, and now we want out?
So awesome question. Technically, agents aren't parties to the contract, right? They're third-party beneficiaries. The true parties are the buyers and sellers or purchasers or whatever you want to refer to them as. So yes, those are the true parties, provided they're signed, they're contracted to that. The reign contract, and I'm going to step out of an attorney and put a personal hat on for a second, so take this for what you may, but in other jurisdictions, you don't necessarily see a ratification area for the agents to sign. So it is unique to the Hampton Roads area, the reign contract. With that said, though, that is one of those things where you can then open yourself up to have a client say, you know what, you didn't do your job. It's because you didn't sign this on a timely fashion, when you should have, because you knew there was an area for your signature and there's a timestamp to it when you DocuSign, that I don't think you really, you know, timely assisted me in my advancements to want this house. That can expose you to a D4 complaint potentially. That can expose you when you have one of those clients that are either looking for a scapegoat or just can't really understand the nuances of contract law, which, you know, we can't blame them if they're not experts in the field or if they don't do this all the time. But from a technical standpoint, yes, buyer and seller are parties to the contract. It just requires their signatures to that to make it legally binding. It does throw kind of that red herring in there with the ratification section, and there's not a lot of litigation on this. So it's kind of like up to first impression in the courts if it ever got there. But my legal position would be, hey, again, third-party beneficiaries don't need to be signatories to the contract. It doesn't affect their benefits at all. These are really the consequences and benefits for the parties. And that's all it states are the parties. It doesn't say parties, listing firm, selling firm. It doesn't say anything like that. And if you look at other parts in this contract, it does explicitly refer to listing firm, selling firm. So here, if we go on the plain language, it's just the buyer and seller. But yes, there's been some communication about that ratification area, and it's my legal opinion. Again, that's just an additional step. But for best practice, I would encourage you to always make sure you all timely sign it because of the fact of exposure. All right, I'm going to move on. Let's see, key points. Inspector must be D4 licensed. If PICRA is utilized, then buyer must provide entire inspection report to seller, or buyer can unilaterally terminate and send a release without providing the report. So technically that home inspection is property of the buyer because they purchase it. But if you want repairs, then that has to be sent over to the seller. Day 6 is that additional day that allows the buyer to terminate. So again, the seller shouldn't operate anything on day 6. They should wait until day 7. And then day 7 is when the seller can go ahead and terminate. And then we have, these are just kind of like examples. I know we're coming up on the heels of 11. Let's see, we went over some examples. So oh, that's it. All right. Any questions? I know we kind of addressed some things. I see there's 4 comments in the, let me see. Oh, yes, CYA. Yes, Jordan. If a ratified contract has a misspelling of the buyer's name and the buyer does not go further with the process, the buyer stopped the process because of the misspelling. If it's substantially similar to what the buyer's name is, that's a scrivener's error. And so you can always fix it as long as it's correct on title and the lender documents. I mean, ultimately best practice would get an addendum to correct the name. But again, if it's substantially similar, then it should be okay. And that's not necessarily a basis. Now, if it was like, you know, Lindsay Barton and I spell it Lindsay and it was Lynzi, well, they still know Lindsay and Barton's the same. If it were, you know, Sandra Barton, well, that's clearly not my name at all. That could be a totally different person, in which case then there's room to argue that that is potentially a completely different person, not owner of this property. So hopefully that provides some clarification for you right there. Any other questions?
Okay, I have this. I think this is interesting. I did not prep Lindsay on this, but I just want to get your feedback. So this was posted in a group in which we do not comment nor name. However, this was posted and I am curious your thoughts. So I'm just going to read it out. It says, my client wrote an offer on a home. The seller sent it back with everything signed. They simply added in a 48-hour kick out. My buyer signed everything and we sent it back. However, there was an error on the washer and dryer conveying. We had selected for it to convey, and the listing stated that it did not. So per the buyer's request, I called the listing agent to confirm it would convey. She stated, "Oh crap, no, sorry, I was just rushing to get it back over to you." So with everything else signed, I sent it back with the washer and dryer crossed off. This was on a Friday. The seller was supposed to initial that spot and the agent to ratify. Listing agent ghosts us all weekend. Sunday, late afternoon, she calls to say that they received an offer the night before and they decided to accept. This morning, I get a phone call from the buyer's attorney. They are seeking litigation and suing for specific performance. So in the real estate world, I would view the washer and dryer change as a counter offer. The attorney said that we had a fully executed contract and that the strike through the washer and dryer was a known contract defect and would be no different than if we had sent over an addendum because everything else was signed. What are your?
That's interesting. So, I mean, it sounds like to me they did have a fully ratified contract. When she sent over the 48-hour kickback, everything was signed by the seller. And then when the buyers put all their signatures on everything, including that 48-hour kickback, that was meeting of the minds. That was their contract. They contracted to it. Now, the washer dryer may have been what's called a mutual mistake, but that doesn't affect the core of what the contract is to go ahead and sell the property. If it really benefits, it's one of those things where the buyer goes, fine, I don't want the washer dryer, and the seller goes, fine, I want to keep the washer and dryer. Well, then no one is really harmed in it, and it doesn't affect the core terms of that contract. So you do have a fully ratified contract. And again, it's based on mutual mistake, and the fact that then they lined it out, to me, is a change after the ratified contract. So that would not necessarily be a counter offer, but it would be, like I said, yeah, a better fashion document would probably be an addendum just to say these are going to be items that are removed, and will convey to the seller upon their, leaving of the property. But it sounds like they did have a fully ratified contract, and it doesn't sound to me that that was a counter. The fact that the listing agent, again, that teaching moment, and I'm sure y'all know this, but never admit, oh crap, I was just hurrying, that's my bad. I mean, it's good to take ownership of your things, but at the same time, now that this is in writing and circulating, what if their client sees that and it ends up in litigation and it was like, well, if you would have just taken your time and, reviewed it one last time, we woun't be in this mess. And it's because of you just never know. People are really litigious. They're getting more litigious. They never want to take responsibility. They always are looking for a scapegoat, and it's not applicable to everybody, but in human culture, that's just what we see a lot. And so in that regard, that is an interesting scenario. I would love to probably track that and see what comes of it, but I am inclined to say there was an acceptance and a ratification of the contract. And
so can I add on to that real quick?
Yeah,
because I'm curious, if that was a ratified contract, then, so say like nothing else, right? So it's just buyer and seller agreed on a Sunday night, but whatever agent was the last one to receive it is like, I'm having trouble getting my home inspector within this 5-day contingency. They can come on the 6th day or whatever, but I can't get them in. So I'm going to ratify it tomorrow to have the timeline start. So when would the timeline start? Would it be when the agent ratifies the contract the next day? Like say it's 10 p.m. they get it back and they're like, okay, cool, I've got it. I'll ratify it tomorrow morning. Or do the timeline start when the buyer and seller both have fully executed the contract?
but you're saying the age. Oh, I would. That's a great question, because oftentimes I always look to when the last signature was signed by the parties. But there is that section where I do know the attorneys look at when the agent signs that ratification block. I would say it's from when the last signature is signed by the parties. And I say that because that is, again, that's what makes the contract binding. And then also that is the best protection, right? So we always default to what's the best protection. Well, if you start the clock, then you're going to be within that 5 days. But if you start the clock later, you might be outside that 5 days and then you expose yourself to litigation. But even without that time frame, I would still say it's when the signature of the last party signs. Again, this ratification box is one of those things where it throws a lot of confusion in. I think it's meant to almost assist, but if the agent doesn't sign the same day as the last signature on the document signed, then it, like Jordan just said in her example, then you have a different date as the ratification. But in terms of that ratification, it's essentially you just sealing the fact that, yes, this is a fully ratified contract. It's not you ultimately being the last to create the ratified contract. And so there's that kind of blurred line too. But that probably doesn't give you a lot of guidance, because there is that argument point on it where people do take a different approach, that it is the ratification box. I take the approach, it's the last signature of the last party.
So we have another question here in the chat that says, if a ratified contract has a misspelling of the buyer's name and the buyer does not go further with the process, can the buyer stop the process because of the misspelling?
No.
So essentially, I mean, it depends the extent of the misspelling. My name, Lindsay, if in Barton, if in there I was the buyer and they spelled my name Lynzi, well, you still know it's Lindsay Barton. In that case, it's not a substantial defect of the contract, it's a Scrivener's error. That could be rectified. Ideally, it would be an addendum, but you don't necessarily need an addendum for that. It could just be, corrected with the settlement agents and make sure the lender has all the correct information. So that's a Scrivener's error. That's not a basis to get out of the contract. Now, if it said Susan Barton, well, I am not Susan Barton. Susan Barton could be a completely separate person. In which case there would be argument to say, you know what? No, Susan Barton is not owner of this property. We're going to need to say that the seller is in fact Lindsay Barton. But if you say that, that's an addendum. Everybody needs to sign the addendum. And then if the seller is not willing to sign the addendum, well, then potentially there could be argument. Well, then you're technically not under valid contract because I am not Susan Barton and I'm not buying the house as Susan Barton and my social security is not Susan Barton and all those things. So it goes back to kind of like variations and misspellings and fat fingers of names. Those are fine because on name affidavits, when they run social security numbers, there's always variations of name spellings, and people know reasonably that Lynzi is the same as Lindsay, and someone just didn't ask proper spelling or they assumed without confirming. And that happens frequently. But again, that's if there's like completely different names, that's another story.
I want to pipe in here just because I have a captive audience and I can. This is Lucy. I'm the compliance broker over at Keller Williams. And I want to just throw down with once a contract is ratified, you don't make any changes to it. It's now written in stone. Any changes to that contract need to be on an amendment. We're not changing ratified contracts, period. Thank you.
Yes. Absolutely. And then you won't get yourself in those situations like this situation hypothetical that Christy read. But yeah, once it's ratified, it's it's almost like offer and acceptance and consideration, right? The offer needs to be taken in its identical form. And if you accept it in its identical form, then you have that contract. Why would you ever want to change it after that? Because then you blur the lines and you open yourself up for just a headache at minimum or a big legal litigation mess at maximum. It's just not worth it, especially when you have that RAIN document that has the addendum and you just need to, fill it out. We do live in a fast-paced life, and as agents, you're always busy, but sometimes it's worth the extra 29 seconds to go ahead and do that. Then it's, worth the next 5 days of going back and forth and trying to, do damage control. So. Any other questions?
This has been awesome, Lindsay. Thank you so much.
Absolutely. I'm so glad we could do it. And I think we're on the books for 2 months from now. Christy and I will confirm with that. But in the meantime, feel free to reach out if you have any questions. Would love to meet y'all for coffee or anything to actually put faces to names. Whatever I could do to be an assistance, you have my information right on this slide. Otherwise, y'all have a good rest of your day.
Thank you so much. We appreciate you.
Absolutely. Bye-bye.